You may be seated. I'd like to call this court now to session. Prosecution and defense, are you guys ready? Prepared?
Yes, Your Honor.
All right, we're here to convene a session of the impeachment of President Justin Bruno and Vice President Devin Harrison. Prosecution, you may come up with your opening statements at this time.
Good evening, everyone. Greetings, Your Honors. On behalf of the people, the students of Florida A&M University, I am here to present the case for why the defendants, President Justin Bruno and Vice President Devin Harrison, are guilty of the crimes of nonfeasance of duty as it relate to Chapter 602.4, misfeasance of duty as it relates to the Florida Board of Governors, Regulation 6.14, and Florida Statute 1004, Section 4A. The defendants knowingly engaged in an unlawful activity. The timeline is simple. They requested an appeal for a new election, losing all appeals. They were granted that request for a campus-wide election they asked for. They knowingly took offices announced illegally by the Electoral Commission They allowed the Electoral Commissioner ruling to stand despite of their vow to uphold the law because it was for their personal gain. Even knowing the election was not held, it was a disenfranchisement for student rights. They proceeded in including the remainder of student government to act in a manner not in accordance with the applicable laws of this institution. At the conclusion of this trial, the prosecution will be able to prove beyond a reasonable doubt that even after swearing in the president and vice president, was wrong. Additionally, their continuance in their roles under the scrutiny of the disenfranchisement of students is misfeasance because it prohibits the carrying out of what both the Florida Board of Governors and Florida legislators said is student government rights to prescribe the rules of the election. That is all.
Okay, thank you. You may be seated. Opening statements from the defense. Solicitor.
How you guys doing? In the absence of my clients, I will abstain from making an opening statement.
Okay. Before we begin with the presentation of the prosecution, Solicitor, your clients are fully aware of this courtroom proceeding taking place tonight, correct? Okay. And you're still representing. Okay. Now we'll entertain a presentation by the prosecution. If you want to call a witness to the stand, Attorney General, you can at this time.
Okay. I'd like to call my first witness to the stand, Electoral Commissioner Bria Jefferson.
Ms. Jefferson, please approach the podium. You may begin.
Ms. Jefferson, it was my understanding that your predecessor, Adrian Floyd, was the one who issued out the memorandum that there doesn't the president. Is that correct?
Yes.
Was there any type of conversation before she decided on this decision? Was there a vote?
Yes.
There was a vote?
Yes.
Were any minutes taken at that meeting that decided on declaring them the president and vice president?
Yes.
There were minutes at that meeting?
Yes.
So do you now with this situation with them declaring president and vice president, I know you were a precinct supervisor at the time. Did you question the actions on declaring them president and vice president before she decided to move forward with this?
I can't recall at this moment if I went through the thought process.
Okay. No further questions.
Stay on the stand, please. Cross-examination solicitor at this time. If you have questions for the witness. Just make sure any justice have any questions. I do. When the vote was cast amongst the EC to basically, however it says in the minutes, basically not have the new election that was mandated by the Supreme Court, could you just please explain to this body the thought process that went on behind that?
I don't recall the thought process.
You were present, correct? Lori?
Yes, but I don't recall what I was thinking at the time.
Okay. Any other questions from the justices? No? You may step down. Thank you. Counselor, do you have another witness?
Yes. I'd like to call Simone Nesbitt to stand.
Good evening, everyone.
Simone Nesbitt, for the record, can you state your current position in the Student Government Association?
I am the Organization and Finance Committee Chair of the 46 Student Senate.
Now, I'm aware that you were the maker of the motion that decided on impeach Justin Bruno and Devin. I'd just like to ask, what was your intent?
My intent was, go close to the mic there. My intent was to make an effort, the best effort that we could, to follow up on getting our student rights back into our hands as it relates to our voting or our ability to hold an election and elect candidates and carry out the process that is prescribed to us in not only the state law, but the Board of Governors regulations, the statutes that we have.
Okay. Anything else?
Would you like to rephrase another question?
Now, as a student leader, what do you think of this whole situation as a
I think that the student body is generally confused, and that's been the sentiment since January of last year. We're in a situation, and I made the analogy, which I thought was pretty witty. We're in a situation where we had something kind of like a robbery of our student rights. And so I would say that the memorandum was the idea of, the robbery. And at the point that former Electoral Commissioner Floyd put that memorandum up and and basically ran off with our student rights, the Division of Student Affairs, Dr. Hudson, led by Dr. Hudson. Justin and Devin had the right not to assume those positions. They could have said no. They could have not willfully participated in usurping our student rights. They could have maintained, as we, the current student leaders and rightful student leaders, maintained under the oath that we uphold, that there should have been an election. There is no escaping after you take the oath. You willingly take the oath. There's no escaping the documents that we have. Everyone has access to them. They're on the student government website. They're on Google. There was no reason to bypass something so simple as black and white. It wasn't in French or Spanish. It was plain English. There should have been an election for multiple reasons, starting with it's the law.
Thank you. No further questions.
All right.
Right. Ms. Nesbitt, please stay on the stand. Did I just miss you? No, it's fine. Any questions for the justices? No. You being the the senator that made the motion, you said earlier robbery of student rights. I just further elaborate, like, 'cause you're a student, just like I'm a student as well. When you talk about that robbery, as a student leader, how do you feel the process should have happened between the EC and the Declaration of Candidacy, and therefore to instill that students' rights were not violated at this point?
Okay, so if I'm not mistaken, the argument was made when it came to the reasons or reason why that memorandum was posted, and the argument was allegedly that, well, Pernell and Victor were disqualified. Well, they were never qualified, which meant that instead of, okay, so at the point where somebody becomes disqualified, that means that there's an election going on, they violate something, they get disqualified. Well, there was no election to begin with. The ticket should have been Bruno Harrison versus Noda, which is none of the above, which never happened. So that's how we get into this predicament. And with the memorandum, there were complaints filed about that, and the feedback that we got from Dr. Hudson, I believe, was that, well, no one contested within 24 hours. And our Constitution in Article 5 doesn't prescribe a time period of appealing to an official of the administration, like student affairs. The process, actually, I can read it to you guys because I don't want to misquote. It says that student rights. The accused shall have the right to counsel, et cetera, the right to appeal for a closed trial, the right to obtain discovery pursuant to his or her defense, and the right to a speedy trial. Where we are is, and the right to appeal student Supreme Court decisions to the Vice President of Student Affairs. So at the time, there was no quorum of the Student Supreme Court. Nobody could appeal for someone to then appeal to Dr. Hudson. So that whole chunk of our Constitution got skipped, and then people started making up rules about nobody contested in 24 hours, and then suddenly we had a new president. That is how the situation went on our side.
Okay. No other questions from the justice? Senator Nesbitt, you may step down. Thank you for your time. Counselor, any other witnesses?
Yes. I'd like to call to stand Senate President Randy Johnson.
Good evening.
Mr. Senate President, on numerous occasions you made public attempts to get the Electoral Commission to comply with everything. There were different discrepancies in the law and the execution made by the Electoral Commission prior to them being installed. Now, I know on numerous occasions you did attend an administrative panel hearing to try and sit down with the administration, and of course from various Senate meetings, I did observe that you tried to, get something done. Now, what happened at the, at these Senate meetings, and what happened at these administrative panel meetings? What did you bring to the to the table to let the student body know that they were deprived of their rights?
Right. So what happened is on January the 11th, I received an email around 9 o'clock in the morning from the Electoral Commission saying that there was going to be a halt to the process of the election due to a lack of funding and a couple other issues that they described. And that same day, towards the evening, of course, the letter was posted outside of OSA that there was an election result and that Bruno Harrison had won the election. I then requested in writing to the Attorney General to investigate those improprieties that we saw that happened as far as election not taking place as described in our documents. After that, there was a series of memorandums to administration, to the EC, emails back and forth, special Senate meetings to kind of understand what happened and what we can do as a Senate to move forward with student government. The Electoral Commission decided to recuse itself from any investigation of student government until the administrative hearing panel took place. It was then scheduled from the Electoral Commission administration that the parties of SGA leadership, Bruno Harrison, EC, and the subsequent advisors or directors to those departments to meet. At that meeting, everybody sort of except for Bruno Harrison. And what took place was a series of conversation where we kind of said our part when it comes to what happened and what did not happen, which essentially election did not take place as prescribed by the Student Supreme Court and reinforced by the Student Senate. The administration repeatedly kept using the point that Senator Nesbitt just brought up, which is that no contestants took place. But as we kept arguing, is that no contestment took place because there was not a proper election to contest. That's what we were investigating. And it came in between a lot of interpretations between what does contestment mean versus investigation. I repeatedly said that an investigation is not a contestment, that's a separate thing that was done by Attorney General. What did not happen is that there was no resolve, I guess you want to call it that, for that meeting. And then we still end up to where we are this day, where administration has recognized a leader who has not properly assumed the rightful office because there was no election taking place. And that's where the Senate has been for the last, I guess you want to say now, almost a month, as far as trying to get rightful student leaders back in office.
Student leaders that
Right. What happened after the election was a bit of a quick transition of power, if you want to say that. After the election notice was presented, it came to my knowledge the next day via Facebook and Twitter that there was a press conference had in which the vice president and president had been sworn in a private ceremony, and that there was a transition of power that took place. And the only message that we got was to move forward. And as you all know, that's not how we do things in student government. There are processes in place that we have to follow, whether we like them or not, and those rules and guidelines were not followed by either party.
Now, was the swearing in of, with the whole swearing in part, was that public? Was that open to the students? Were students invited to that?
No. What took place is before convocation on that Friday, I believe it was Martin Luther King convocation, there was a memorandum sent from student government to administration. Essentially, as you all know, at convocations, they have the student body president or vice president speak. And because we did not elect a vice president or student body president, we kind of put a halt to that. And so what took place after convocation, as many of you all may know or may not know, there usually is a private reception or ceremony after, usually in Al Lawson, where there's food, stuff like that. And that's where, to my knowledge, the swearing in of the president and vice president took place. And that was not a public ceremony where people were invited.
And when a student president, vice president are sworn in, they are to be sworn in front of the student bodies, they can witness that, correct?
Yes, correct. In past, it's usually been an inauguration ceremony, usually outside on the quad. And last August, myself, Pro Tem Webster, along with President and Vice President Paris Ellis and Jalen Smith, were sworn in front of us at a Senate meeting for a public ceremony.
Thank you. No further questions, Your Honor.
Defense, any questions for cross-examination of this witness? Excuse me? Any questions amongst the justices? No? Okay. How you doing, Brandon?
Doing good.
So basically, when the commotion started, you said dating back to January 11th when you were notified in the morning of the transition of powers when it came to the SGA presidency. During the time of confusion between then all the way up to even now, have you sat down and spoken with President Bruno or Vice President Harrison or administration to try to rectify the confusion kind of in-house before it explodes to where we are today?
The only conversations I've been able to have has been, unfortunately, through memorandum and email. President Bruno and Vice President Harrison have not reached out to myself. Of course, you all know we work in the same building. They have been invited to Senate meetings. I've been told that even other senators have reached out personally to have them come speak. They have not. On this past Monday, the Senate actually passed a motion to require them to come give an e-branch report to kind of, just if you're going to work here, you have to at least be able to come speak with us. The only conversations I've had with administration, like I said, I've been through either memorandum or the administrative hearing panel in which there was a conflict on interpretations of documents. Essentially, administration has only said up to this point that we need to move forward with a transition of power, and that because no contestment was made, that nothing else could be done on their part, which is incorrect.
So basically, administration strong arming Student Government Association.
Essentially, that's what's happening, and that's why we are where we are today, to put our foot down as student government, to say that you all don't determine who our leaders are. We have a process in place for that, which was not followed.
Okay. Any questions? No? Thank you. Oh, did you?
No, no further questions.
Thank you, Senate President Johnson. At this time, we'll entertain presentations from the defense solicitor. At this time, you can approach. No presentations. Solicitor, were you properly prepared for this meeting and you met with your clients, and were they compliant to your meetings and sit downs? I know they weren't present at the pretrial motion hearing. Could you explain to the Supreme Court basically why they're not in attendance or lack of presentation or anything up to this point?
My client just showed up to be here present today.
Did he waive his right to counsel? No? So, okay. At this moment, we'll have oral arguments from the prosecution and defense. Shall address the points of law that's being appealed to the Supreme Court. Each side will have 30 minutes to present oral arguments. Prosecution shall go first, followed by the defense. The justice may interpret questions at any of this time, answering for the justice. And at this time, Attorney General Carter, call you to the stand for your oral arguments and your findings.
Good evening once again. I did submit, I trust that you all have read through the evidence that I put together.
Yes, sir.
Okay.
From wherever you want to start, just elaborate on that and present it to the Supreme Court in an orderly fashion.
Okay. So the first thing I put in the evidence was the memos that was sent out on October 22nd, 2016. And then after that, I included the appeals, the right of Q warrants, the public declaration. That's where I'm going to start from. I'm going to start from 6 and work my way down because, as most of you don't know, I inherited this case. So I'm going to start from 6 on down. On January 11th, the EC decided to declare Mr. Harrison, Justin Bruno and Devin Harrison president and vice president. On January 12th, there was a memo sent out via FAMU info. And then once that memo was sent out, I was requested by the Senate president to investigate the whole process. So once I did my investigation, I did find that the declaration that I did find that the EC did break the law by declaring Justin Bruno and Devin Harrison as president. There was an election that was supposed to happen, and the election should have taken place. Once I did that, I did request that Adrienne Floyd, the former electoral commissioner, come to the Senate chambers and speak about her findings, but she constantly recused herself up until the point of the administrative panel hearing, which I was present at, and I gave my findings and let them know at the administrative panel hearing that students were deprived of their rights. Students should have had a say-so in this.
Okay.
And now we're here. Now we're here at a crossroad. In our Constitution, it says there's an oath. They swear, they defend, they uphold, they abide by the Constitution and the statutes of student government. Justin Bruno and Devin Harrison took the oath knowingly breaking the law. Now that was wrong. From my research, I am aware that Mr. Bruno did serve in student government prior to running for president, and he should have known the law, but they chose to break it. Time has went on. Every moment that has elapsed is a moment that the president and vice president failed to defend against the administration law of student government because it suited their personal gain. And what I mean by that is, time and time again, the Senate met, memorandums were sent out, but not one time did our president and vice president come to the Senate and address the student body. Not one time. They didn't come out. They didn't send out an email. But yet, they got up at Black History Convocation and said their two pieces. The daily, and now student government is, like I said, at a crossroad. As a former senator, Justin Bruno is aware that the rulings in the courts are final and not subject to, reinterpret, except by the court itself. He co-signed and executed illegal acts that the Electoral Commission and chairwoman, who isn't here, Deja Sawyer, bestowed upon themselves that belongs solely to the court. I'm on ethics counts now. Their failure to act with integrity for the benefit of their own ambitions is wrong. They ignored what was not just right, but they ignored the laws, And to make matters worse, they were likely to win against a NOTA opponent, but their minor time inconvenience was too much. The problem is, after piecing this whole case together, is students were deprived of their rights. And now students have leaders in place that have broken the law, but they expect their E-branch and everyone else to follow the law. How can you have leaders in place that are supposed to lead us, but they don't follow the rules? That is all.
I just have a quick question before I open it up to the other justice of the Supreme Court. You mentioned Deja Sawyer. I see here on the pretrial motion that she was one of your witnesses that you request from the courts for a subpoena.
Yes,
You did reach out to Ms. Deja Sawyer, correct?
I did reach out to Senator Sawyer. I did not get, only thing I got was a email. I did try and reach out to her time and time, but from what I was told was her phone was broken. But she is aware that she is supposed to be here tonight to answer questions about her and her position as the ENA chairwoman, elections and appointments chairwoman.
Okay. Outside of that, any justices have any questions?
Yes, and
Hold on, sweetheart.
what did the emails exactly say, or what was her response to the emails?
Well, she sent out an email, and she claimed that I sent it out at 3:49, which I didn't. I sent it out. It was a subpoena, asking her for her presence here today. And she did. Her and I did have a verbal conversation before the pretrial hearing, and I let her know that I'm going to be sending her some documentation, and I let her know that she needs to be here.
Do you have a copy of the email?
I do have a copy of the
Or maybe like a time where we could see
timestamp when I sent that
Yeah.
email. Yes, I do. Give me a second here.
While you find that, you did say you spoken with her earlier, correct?
I only through the email that was sent out,
Okay.
but she is aware that she is supposed to be here.
Okay.
It's okay. If you could just
I can.
elaborate on maybe what the email.
The email was basically she was questioning. She said that she was supposed to get a 3-day notice.
Oh, you talking about discovery period?
The discovery period. The discovery period notice. Because once Chief Justice Nelson sent me the subpoena, I sent it out to her. But she was aware that she was supposed to be here today. She was aware because of our verbal conversation yesterday, and she was aware the email that was sent out, and also she does have my contact information if she needed to call me or something before the trial. So my last communication with her was yesterday after the pretrial hearing when I saw her verbal conversation, and then the email that she sent out questioning about her being here. But she knew that she was supposed to be here. Because even the other people showed up, and they did not question anything, but they knew that they had to be here. So yeah.
In your emails, I sent you guys, I forwarded you guys the response when Deja Sawyer presented that question, not only myself, Attorney General, and Ms. Tatum. And you guys can follow up on that. Any other findings for your oral arguments, Counselor?
That is all for right now.
Okay. You may step down.
Thank you.
Solicitor, I'm asking you to please approach the stand for your oral argument, however lengthy it may be or may not be for your defendant, please.
Would it be in questions presided? For the reason to take this down?
I feel it'll be due process for you to defend your client, at least in the oral argument, if there was no facts found for admission of evidence. Please approach the podium. And basically in your argument, just explain for the defense of your client at this point in time.
I mean, if there's no questions, there is no arguments as well.
Are you sure?
Yes, sir.
Any questions on the Supreme Court? No? All right. You may be seated. So, at this moment, I'm going to call you back, Attorney General Carter, for your closing statements before the Supreme Court goes into deliberation.
Your Honors, it is time for us to move forward. I presented as much facts as I can. I've sent out numerous emails, but it is time for us to move forward. Students deserve leaders that follow the rules. And we cannot move forward with the two leaders we have in place. What kind of example does that set? What does that say about student government? And my job as Attorney General is to represent the best interests of Student Government Association. And we cannot do that with leaders that blatantly breaks the rules. I laid it all out there on the table. I've been investigating this case for the past 28 days, even though this started a year ago when I wasn't here. But it is time. It is time for us to move forward. It is time for us to ensure to the over 9,000 students at Florida Agricultural and Mechanical University that we have a working and functioning student government association. We have honest leaders in place that follow the rules. And the two people we have right now serving us are not doing that. Think of the students. And think of the students that come after us. What are they going to say tonight? What are they going to say in the future after the verdict is rendered? I rest my case.
Before you step down, one question from Associate Justice Maurice.
Hello, just one quick question. What would be your response to maybe the students that say because of this short time period, another change in power or transition may not be the best route? Just what would you?
If there's a change in power?
Yeah, like what would you say to students who maybe not agree with this change in power because it's so close into the semester or because SGA has already been having so many transitional powers?
I would tell the students that change in power is because of rules haven't been followed. And if the people after them don't follow the rules, we keep going. It is time for this student government to have some positivity. There is so much negativity said about this Student Government Association. And we cannot continue down this path. We cannot. Time and time again, my favorite statement is for the sake of the students, for the sake of the students, for the sake of the students. The students deserve honest leadership. They deserve leaders who are going to follow the rules. How are you going to lead us? But you're breaking the rules and you expect us to follow the rules. I think the students would be all right with a change in power. It happened last semester when they kicked out Magnum and got Robinson. We moved on. We will move on again.
Decorum in the gallery. You may step down. Thank you for your time. Solicitor, if you have a presentation for your closing arguments, you may approach the stand at this moment. No presentation for closing arguments. Okay. At this time, the Supreme Court shall retire for deliberation. We'll come back to you with a verdict at this moment.
All rise.
Pick FAMU because of the school spirit. Because it's a family. Strike with us. Strike with us. Strike with us. Strike with us. I chose FAMU. I chose FAMU because of our rich culture.
The only reason why you should choose FAMU is the #1 HBCU in the nation.
Strike with us. I chose FAMU. I love FAMU. You should. Strike.
I always loved science as a kid. At the age of 14, I developed an innovative stitching technique. I decided to hone my skills at Florida Agricultural and Mechanical University, majoring in chemistry. FAMU's learning environment has pushed me forward in making my dream of becoming a trauma surgeon a reality. Oh, did I tell you my twin brother is here too? FAMU has pushed me forward in my college career path of becoming an environmental attorney. So what are you waiting on? Let FAMU push you forward.
Court is in session.
You may be seated. The findings of the Supreme Court will vote unanimously that SGA President Justin Bruno and Vice President Devin Harrison violated Student Body Statutes Chapter 602.4, subsection C, Florida Board of Governors Regulation 6.014, subsection 7, and Florida Statute 1004.26, Section A and Section B, along with the student body documents of Florida A&M University. It is this court's decision that the SGA Association, Student Government Association, follow the orders of session outlined in Article 4, Section 7 in the Student Body Constitution. The naming of the newly succeeding officer will be announced at the following Senate meeting during the district branch report. Court is adjourned.
All rise. Court has adjourned.